Hello everyone, my name is Pawan and I welcome you all towards our YouTube channel of Art of Law. As part of your All India Bar examination ka preparation, we are learning administrative law. This is a rapid quick revision round. Now I'll tell you for your upcoming bar exam, you do not have a separate bar act for admin law. But remembering the concepts will be very helpful for your AIB exam. It is more than enough for you to clear this particular exam also. Admin law, jo bhi we're going to revise now. Jo bhi we're going to learn now, it's more than enough for you. So, but before I start, I want to start with one question for you. I want you to do your homework and then come back to me and tell me which is right or wrong answer. That is question number one. Which doctrine ensures that administrative law authorities act within the limits of their power? Is it doctrine of proportionality, doctrine of legitimate expectations, doctrine of ultra virus, or doctrine of power, separation of powers? This is your first homework. From now onwards, I'll be teaching you. From next second question onwards. Okay, let me know in the comments. I'd be happy to know about it. What is your viewpoint? Which case is considered in a landmark the recognition of doctrine of legitimate expectations in Indian administrative law? So the doctrine of legitimate expectations from a respective authority needs to be fulfilled, and this major aspect of doctrine was actually being emphasized in the case of the councils of civil service union versus the ministry of civil service. This is very much important. You need to by heart this particular case law. Which principle is violated if an authority acts with bias while performing its quasi judicial function? And the answer is rule against bias. Very simple. If I am an IAS officer, if I'm performing something on a bias manner, then under rule against bias, you can put me up or I'll be punishable for the same. What does the doctrine of proportionality primarily deal with administrative law? Delegation of power, separation of power, adherence to fundamental rights? No. The answer is maintaining a balance between means used and intended objective. That is called as what? Doctrine of proportionality. Very important. Just make sure that you're learning it. Somewhere just write it down in your book itself. The doctrine of proportionality means what? Maintaining a balance between means used and intended objective. So you have to create a vacuum of performing your duty within the aspect of means as well as within the aspect of your objective, considering what power you're trying to hold. Now, which case highlighted the post decisional hearing does not sufficiently satisfy the principles of natural justice? That was in AK Kraipak versus Union of India case. So these are just like quick running up mind questions. You need to by heart certain kind of question. That's why I just started with that. From now on, it's Joby. I'm going to revise now. This is very much important. Okay, very important. The principle of delegatus non-protest delegate means the delegate cannot further delegate. That means that if I'm appointed from the government as an IAS officer, IPS officer, I cannot go further subdelegate my powers to another person. No, that is not possible. That is not as the delegatus cannot further delegate. I hope this is clear for you. Which case laid down the principle of natural justice are applicable to administrative proceeding? So natural justice, so before and all, no, there was an assumption that natural justice is only for people who is working in the judiciary or court, but not at all now. Now they're clearly telling in this from this particular case, AK Kripa versus Union of India. Most of the time, very important cases of administrative law is AK Kripa versus Union of India case. It says that what natural justice has also been applicable for administrative proceedings. The Ram Javaya Kapoor versus the state of Punjab case, they mentioned about doctrine of separation of powers between legislative, executive, judiciary. The three separate doctrine of separation of powers was laid down in this particular case of Javaya Kapoor versus the state of Punjab. The administrative law is a part of public law, private law, common law, international law. The answer is very simple. The answer is the public law. It's very simple answer. If a quasi-judicial authority violates natural justice, the appropriate writ is called as certiorari. Very important. So I'll teach you this 5 kinds of writ. Okay, write it down somewhere now itself. I'll just teach you habeas corpus. Habeas corpus means what? Habeas corpus means to unlawfully detaining someone. For example, if Pawan is being arrested in the prison without any particular lawful manner, simply they have been arresting you or not telling the reason behind it, it's called as habeas corpus. You can go to the Supreme Court or you can go to the High Court under Article 32, 226 and file a case for it. Now, second one is mandamus. What do you mean by mandamus? Mandamus clearly says about what? Mandamus says about we command. For example, being an IAS officer, if I don't perform my respective duty, then under the writ, you can file a writ petition to the High Court or Supreme Court, and then you can tell that the court will mandate me to do this particular thing. That's mandamus. So from writs, normally regular questions have been asked from administrative law, as well as that AK Kripa case, regular questions have been asked. Certiorari means what? Certiorari means the court, the Supreme Court or the High Court is quashing the decision of the lower court. So any higher court quashing the decision of the lower court is considered to be certiorari. Okay, that's very much important. Prohibition means what? Prohibition means stop the lower court from proceeding the case. See, a case has come to the lower court. The High Court or Supreme Court will tell they'll prohibit you to further continue with the case. That's called as prohibition. Quo warranto means what? The quo warranto is very simple, nothing but by what quality, by what authority are you holding the office? Am I having that real qualification for me to have that respect to office? That will be checked. That qualification aspect is coming under quo warranto. Keep this in the mind. Now let's go with our this question, fifth question. If a quasi judicial authority violates natural justice, okay, quasi judicial authority violates natural justice, the appropriate it is called as certiorari. Very simple. Okay, if they're violating the natural justice and they're passing anything, then they can quash it. For example, quasi judicial, for example, lower court. Just imagine, I'm just giving an example. Lower court doing something against natural justice or something, they can quash their entire proceeding itself. Similar way, even for administrative functioning too. The writ of certiorari is issued against what? The lower courts or the quasi judicial bodies. Again, this is the correct answer. Seventh question is about which writ is issued to enforce the performance of public duty by an authority. Mandamus. Public duty. Being an IS officer, it's my duty to perform it. That's called as mandamus. Which writ is issued to quash the wrongful orders of the or lower court? Certiorari. Okay. Quash. Whenever you find the term called as squash, certiorari is the right answer. That's very much important key term you should be knowing. Which of the following courts tribunals cannot entertain a PIL? Okay. So it's obviously the Central Administrative Tribunal. Only Supreme Court and High Court can do it. Supreme Court can do it under which article? Article 32. High Court can do under Article 226. So keep that in the mind. The functions of executive can be classified as discretionary powers, delegated functions, and quasi-judicial function. So in delegated powers, what do they have? The delegated powers and administrative body, they can make rules, they can make bylaws, to everything they can do. In discretionary function, they also has the power to take discretionary actions. Quasi judicial functions also, they have the power for it. So all of the above is the right answer. So here ends our administrative law. Very important concept for your AIB exam. Make sure that you're revising it parallelly again and again. Only then it'll be going inside you. So wish you all the best, good luck, and do let me know in the comments about the first answer and what kind of video you want me to upload more on. These are just the important topics. Make sure that you're referring and leading. In 7 minutes, rapid revision round.